Today we're breaking down the case of Stuart v. the Queen, 1974, a dramatic legal battle with firebombing, gang connections, and legal principles that are still relevant in VCE Legal Studies today. Let's start by decoding the citation. The full title is Stuart v. the Queen, 1974, HCA 54, 1974, 134, CLR 426. This tells us the case was decided by the High Court of Australia in 1974. It's case number 54 for that year, and you'll find it reported starting on page 426 of volume 134 of the Commonwealth Law Reports. Stuart is the appellant, meaning he's appealing a previous decision. The Queen, or R for Regina, is the Crown, representing the state in criminal cases. This case revolves around a horrific crime that shocked the nation. On March 8, 1973, the Whiskey Ogogo nightclub in Brisbane was firebombed, resulting in the deaths of 15 people. 2 men were arrested shortly after, John Andrew Stuart and James Finch. They were charged with the murder of one of the victims, Jennifer Davey. The police alleged that Stuart was the mastermind behind the attack, and Finch actually lit the firebomb. There were also suggestions of extortion and possible links to a Sydney crime syndicate. The idea was to scare nightclub owners into paying protection money. This is a great example of a planned, organised criminal offence, a theme that often appears in VCE legal exams. The trial was controversial. Stuart dismissed his lawyer during the trial and swallowed pieces of wire, requiring surgery and time in hospital. Because of this, he missed parts of the trial. Under Section 617 of the Criminal Code 1899, QLD, a judge can continue a trial even if the accused is absent, and that's what happened here. But the legal issue that really mattered on appeal was whether Stuart could be held responsible under Sections 7 and 8 of the Criminal Code. Let's break those down. Section 7(d) says, if you counsel, procure, or assist someone in committing a crime, you're just as guilty as the person who did it. Section 8 says, if 2 or more people have a common intention to commit an unlawful act, and a crime happens that was a probable outcome, everyone involved can be charged with that offence. So even if Stuart didn't light the firebomb himself, if the plan was shared, and murder was a foreseeable outcome, he can still be found guilty. Use this case when discussing accessorial liability or common purpose offences in your exams. Stuart argued that he wasn't present and should not be held responsible for the deaths. But the trial judge, and later the High Court, said that his involvement in the plan was enough. The court accepted the idea that Stuart and Finch had a shared goal: to intimidate nightclub owners. The firebombing was a probable consequence, and therefore both men were guilty under Section 8. Stuart's appeal was taken to the High Court of Australia, but here's the outcome. The High Court refused his application for leave to appeal. That means they declined to hear the appeal because they believed the original decision followed correct legal reasoning. The High Court supported the trial judge's interpretation of the law. They agreed that Section 8 applies and that Stuart could be convicted even if he didn't light the fire himself, because the death was a probable consequence of the plan. They even praised the trial judge's careful handling of the complex legal issues. This case is a must-know for questions on parties to a crime, common purpose offences, appeals and High Court authority, and how courts apply Sections 7 and 8 of the Criminal Code, QLD. It also shows how a person can be held criminally liable even if they didn't physically commit the crime, but helped plan or enable it. If you're writing an exam response on criminal responsibility, you can use this case to illustrate how courts interpret shared criminal intent and the power of accessorial liability. And that's it for Stuart v. the Queen. A dramatic case, yes, but one that teaches us a lot about criminal law, joint enterprise, and how our courts interpret intent and responsibility. Keep this one in your back pocket for SACS and the final exam. You never know when it might come in handy.